Okay, Brian, you are the host again.
Okay. And so I go to participants?
No. You're good now. You're good. You're the host.
Oh, okay.
You're
Perfect.
fine. I'm recording. We're good.
All
So
right.
let me just start with a quick intro, and we'll go from there.
Okay. Perfect.
Guys, thank you very much for joining. We're going to have looks like we are at 10 right now, which means we'll be at about 25 people in a couple of minutes. Thank you very much for everyone's attendance. I would tell you all, firstly, as an administrative matter, that all of our videos are public. They go on public websites. Our group is private. The videos are public. So anything said today is being recorded, and please be advised. We are thrilled, so to business. We are thrilled today to have Brian Madigan back. Many of you may know his first agreements on just deposits. Actually, it was probably one of our most popular recordings to date. I learned a lot from it. Everyone learned a lot from it. And in fact, it continually makes its way to the top of our group feed as people discover it and then comment on it. So very, very grateful for Brian presenting that. And of course, that wasn't a fluke. Brian is one of the best presenters and educators in our industry. And he's here today to talk about a very different subject, terminating agreements. And I don't really think I need to say more because any words I use are wasted as compared to what Brian is able to fill the hour with. So Brian, I'm going to turn this over to you. Look forward to hearing what you have to say. Thank you again for joining us.
Okay. And so please interrupt me if anyone has a question or raises something. I'm happy to respond to it. Now, what I do know is that once I move into the slideshow, the only thing I actually see on my screen is the PowerPoint. So I can't see anybody raising hands or any chat function or anything like that. So Mark, if you're able to respond to that, happy to pause and respond to any questions that people may have.
Brian, I'll monitor it.
Okay. So this section was a lunch and learn, which I did a couple of years ago, and it followed the really, in a sense, the rising market of 2017. This is this was the time when prices escalated substantially, and then people found that they couldn't close. And it's very important to be aware of your rights and to maximize your interests, whether you be a buyer or a seller in that type of a market. So what we're looking at this morning is how to terminate an agreement properly from the seller's point of view and from the buyer's point of view. It's handled a little bit differently, and as you can probably appreciate, it's the exact opposite of one another. So the case that we're going to have a look at was the first of the 2017 cases, and it was quite popularized in the media, Gamow and you. And the buyer had lost $470,000. Now, of course, there's judgments subsequently which are substantially larger than that. But at this point in time, this blew away everyone, and no one could appreciate that this could arise out of a real estate deal. Now, I've written several articles about it, and what I don't like to do is necessarily put in people's names, their brokerages, and the names of lawyers and so on who are sort of known to all, especially when this is a motion in court. It could be appealed. There could be other litigation arising as a result of it. Nevertheless, media did refer to the people by names, but I generally try not to. So there are some participants in here, a little more relevant for some of the articles that I've written about it. But not really for this particular presentation. So one of the things to bear in mind is I have Fred Flintstone was the listing agent, and Barney Rubble was his associate. This is a situation where we're looking at a timeline and a summary of the case by Justice Edwards. And this was in the judgment that he wrote on the 6th of April, 2018. So what we have is the property was listed for $2 million through ABC Realty. You say, okay, that's a fair amount of money. March of 2017 was the time. So this is basically what we're looking at is 2 weeks after March break. So this begins to be the beginning of the spring market. Now, over a couple of days, basically 5 days, we have 18 showings. Now, this little section here marked in blue are my comments that I'm referring to. The 18 showings are right from the judge's notes in the judgment. Now, on April 1st, buyers viewed the property with Barney Rubble of ABC Realty, and he had been referred by the listing agent, Fred. And so in this situation, what we have is multiple representation immediately. So what we have is whether it's a sign call or open house that they had seen it. Initially, they're placed with Barney Rubble, who is an associate of Fred's in terms of the sale of the property. But what we do have is a multiple representation situation. So this is something that you should bear in mind in terms of your real estate practice, how things necessarily would be handled in that type of a situation. This wasn't an issue in this particular case. That is, for the purposes of the judgment, that issue was not relevant. Now, on April the 1st, the buyers specifically stated, we do not wish to become part of a bidding war. I say, okay, fine. Presumably that would be noted. People would be aware of that. That would appear perhaps in emails, in correspondence, in text messages, or maybe it was just oral. In any event, that was a known factor that they didn't wish to participate in a bidding war. And they submitted an offer for $2,050,000 for this particular property. Next day, there were 3 potential buyers with offers, so we're now in multiples. The buyers were advised by their own agent that they were in multiples, and were also told that their offer was too low. So what did they do? They immediately increased their offer by $200,000. That's strange when you kind of come back to the fact that they've emphasized that they don't want to become involved in a bidding war. In any event, let's move on, because it wasn't part really of this particular case. 2nd of April, the offer was accepted. The terms of the agreement were an initial deposit of $30,000, a second deposit of $90,000 to be paid on the 6th of April, and a closing date about 5 months out. So that's a long closing. Typically 60 days, perhaps 90 days, but end of August, that's the end of the summer, is kind of a late closing. Buyers paid the initial deposit of $30,000 right away, as agreed. Now, we have a problem, and that is 1 day later, April 3rd, 1 day, not here we are, we're figuring it out and the deal. Next day, we've got a problem. Second day, there's financial issues. You say, well, what's the problem? Well, we don't have the money for the second deposit. Well, geez, how could you not know that you needed the second deposit and be able to put your money together and now have problems in a day? In any event, they requested an amendment to add a few more days to bringing that additional deposit in. So the parties agreed to the amendment. That was the 4 days. They also told the listing agent not their own agent, but went directly to the listing agent and said that they had paid too much for the property. Well, talk about buyer's remorse. This is really starting to go sideways very, very soon. So what were the buyer's concerns? This is the 4th. This is 2 days after they've bought it. They had a financing concern. Will they get approved for the mortgage? You went in without a mortgage condition, and you bid another $200,000. In any event, they were concerned about financing, that they'd be approved for the mortgage on the new property, and also the assessed value of their own home. Okay, so they've got a property to sell in this same market. They say, well, this is not going to be a good situation going forward, realizing this all pops up within 2 days of the deal. Now, these are comments from the motion court judge. There was no financing condition. The agreement of purchase and sale did not have a condition which would have allowed the defendants a means to extricate themselves from the agreement. And it was not conditional or contingent upon the buyers obtaining the necessary financing to close the transaction. So there was just no way out of the deal. Now, if you're going to go into a bidding war and you're going to structure something like this, be sure, obviously, that you have the funds available or some backup plan if financing falls through or something. Make sure that you've got it and you're well protected. In any event, this isn't the time to find out that you don't have the cash. Now, the buyer emailed the listing agent and advised him that he had made a mistake and advised, I am begging, please reach out to the original agent with a firm offer. Now, what we're looking at here is the motion court judge is trying to determine when does mitigation kick in? What's the date? How are we going to figure this out? And what I've noted here in blue is you'll see, well, that was insufficient. So this little plea of begging is not good enough from a legal perspective. So the next thing, the sellers were advised by Fred, that's the listing agent, of the information they'd received from the buyers, that they had paid too much for the property. So the sellers are already now getting nervous about the deal, and we're just 4 days into it. Now, the buyers failed to pay the second deposit as required. Now, this turns out, of course, to be a breach of contract, the failure to pay the second deposit. But that doesn't trigger either the termination or the mitigation. So we haven't terminated anything. We've just had a breach of contract. So this is of no consequence going forward. Now, the 11th, the buyers actually attended at the property, and they told the sellers in person that they did not have the financing and that they couldn't close the deal. Now, what's the value of that? Actually, nothing. Nothing at all. Zero. This does not help. Now, maybe it gets it off your chest, but there's no consequence in terms of the agreement that you've signed. This doesn't do anything. Now we go to, and subsequently, they then allege that an oral agreement was reached on the porch and that the sellers had agreed to relist the property and that the buyers would compensate them for the difference in the purchase price. It was denied by the sellers, and since 1632 and the statute of frauds, the motion court judge decided, well, I'm just going to go along with the standard rule that we've had for the last 400 years, and that is it has to be in writing. So you can talk all you want on the porch, but it is of no value for the purposes of this agreement. So both parties retain lawyers. Now that's the 11th. So now that becomes a problem. And it's a problem because lawyers, if things were going sideways within a day, please ensure that your client gets onto a real estate lawyer immediately, and they've got legal advice available to them. Don't wait for days on end and a week, 10 days to go by before you retain lawyers. And this is from both perspectives. So, and it would have been helpful.
Siri, dial 416-820-8204.
Calling 416-820-8204.
All right, whoever that is, Matt, I think that's you. Can you please mute yourself?
Okay, so now we bump up to the 19th of April, 2017. Seller's lawyer writes to the buyer's lawyer and advised, quote unquote, that no oral agreement had been reached as alleged by the buyers. Now, what's the consequence to the motions court judge? Nothing. This doesn't make any difference. So thanks for the letter, but there's no value there. Then we flip forward and there's email communications exchanged over a couple of days. The buyer's lawyer indicates that he'd get back to him within a couple of days, and he says that by the 24th or the 25th, and then we go to the 24th or the 25th, and nothing. It's sort of like, okay, you know that this is a hot file. This is a file that is ready to explode. I would have hoped that you would have had a response right away, but they didn't. And there was the missed deadline, which was self-imposed by the buyer's lawyer upon himself. Well, that just isn't a good thing. Now, seller's lawyer writes, in view of the fact that I have not received any, rather than and, response to my previous correspondence, I am instructed by that my clients are proceeding to relist the property and hopefully resell in a timely manner in order to attempt to mitigate. Now, this is the seller's lawyer writing, okay? This isn't triggering either mitigation or it's not triggering termination of the agreement or an anticipatory breach, nothing. So this isn't the date that the motions court judge is looking to. So then on the 1st of May, we have the property relisted. Now this was the exact sale price in the agreement of purchase and sale. So that makes good sense. Let's see if we can sell it for what you bought it for. And so that was done. And then we have a response. Now these are the key words. Here's litigation counsel. So this is the buyer's second lawyer, who I think has had the file for 10 to 12 minutes at this point in time, but knows exactly what to do. So there's no fooling around. We're going to do something right away. We don't have any time to waste, and writes a letter. Here are the magic words. Buyer's financing from the bank had fallen through, and as such, they would be unable to close the transaction on August 30, 2017. Next, we are putting your clients on further notice to take immediate steps to start mitigating their losses by A, immediately contacting any buyers who made offers on April 1st, 2017 to determine whether they may be willing to purchase the property, and B, relisting the property on the market MLS as soon as possible in order to find a suitable buyer. We trust your clients will make best efforts to sell the property for the highest price possible in order to satisfy their duty to mitigate. Now, those are the magic words. That's perfect. No extra words, nothing superfluous, right to the point. It came out immediately after they were retained. My guess is somewhere between 10 and 12 minutes having been retained, they realized that they had to get this out. Now, this is my point of please do this as soon as possible. Both parties went 10 days without even retaining lawyers at all on it. But we need to get to the right person very quickly. And I think that you see that there's a fair amount of money that's at stake by delaying day to day to day. So this ends up being considered by the motions court judge as the actual official notice right there at that point in time. Now, we run 2 weeks. We have no offers, nothing at all, no potential purchasers. Now the price is reduced. So the original purchase price was $2 million. Here we're just making it slightly more attractive by taking $2,000 off it, so that the listing price is now $1,998. So we're back to roughly the original listing price, and we had that 2 weeks to try and get the same price that the buyer. That's a very excellent strategy and usually will work. There are situations in which, if it were much later in the year, this is May, if it were August that we were doing this, I don't think that we have any opportunity to try for a much higher price. I think you've got to reduce it quickly. In any event, strategy-wise, this made good sense. We run a couple of weeks, 3 weeks roughly. There's no offers. 6th of June, sellers offered this, and this was an arrangement to the buyers. He said, okay, why don't we go back to the original buyers and say you have an opportunity, and note the wording, with prejudice as opposed to without prejudice, basis to revive the agreement of purchase and sale. So it's sort of like, come back in. We would otherwise have the right to terminate. We will allow you back in, pay the supplementary deposit, that was the $90,000, and close the deal by the end of August. Now that offer, which I think now when we look at it, is fairly attractive, and I'll point out why I think so a little later on. But it's often viewed as something you just pass by. But this was a pretty good deal. And what it was is just close the deal, just the way it was set up in the first place, and you won't lose any money. Well, you're going to have to sit for a couple of years, but you won't lose any money. So this turned out to be ineffective. That didn't work. The buyers just passed on it. Now, of course, the other issue is they didn't have any, maybe they just didn't have the money available no matter what. The other issue there is sometimes there's funds that are available from a secondary source. So all of a sudden, instead of paying 3 or 4% in terms of first mortgage rates, you're going to have to bump it up and pay 12 to 15 to 18 for second mortgage financing. It would have been wise to have considered that if that were an opportunity that was available. In any event, we run June, July. There's no offers. We have a lawsuit commenced on the 4th of July. We then have the statement of defense filed by the buyers by the end of July. Then we have the price reduced. So we're down now $200,000. This is due to the fact that they're watching the declining market. This is 2017. So we'll look at some of the numbers in 2017 just to see what happened at that point in time. End of July, they actually received an offer for 1.7. And to their credit, they didn't accept it, all right, which calls for a little bit of an explanation in terms of why they would accept it. But here's what they did, which was very good strategy from the perspective of the sellers. They negotiated over a period of 10 days and bumped up the price by $70,000, remembering that the $70,000 extra that they got wasn't really for them, but was going to end up being credited to the purchaser. So this is a very good strategy if you're on the sell side. Now, action actually closed. So the motions court judge stated the fundamental issue in this case is when the defendants repudiate the agreements, repudiate the agreement, such that the plaintiff's duty to mitigate can be said to have been triggered. And that's the key question. So we needed that trigger to put the numbers in place. So it could be when they first communicated their concerns. That was within a couple of days. It could be when they breached the agreement by failing to pay the deposit, or when we fooled around for a whole other month and we finally got that lawyer's letter from the litigation lawyer acting motions court judge determined was the relevant date. So a month not knowing what to do. And yet within a day, the buyer actually knew that he couldn't close, which calls into question a whole series of questions, but they're outside of the context of this particular lawsuit. So the decision was by Justice Edwards, I'm more than satisfied that when it became clear that the buyers had repudiated the agreement, the sellers accepted the repudiation and began their efforts to mitigate their damages. That's what you want the judge to determine. I am equally more than satisfied that the plaintiffs acted reasonably in listing the property in the manner they did. That's $200,000 more than the original listing, so that it might have been a little fortuitous to go with something like that if it was going to be realized, but they only did that for 2 weeks. And thereafter reducing the list prices, which started in 2 weeks after, to the point that they were able to obtain an offer that ultimately closed. So the plaintiffs are entitled to damages based on the difference between the contracted sale price between the parties and the ultimate sale price of 1.78. The plaintiffs are also entitled to special damages claimed. So here's basically where we are. 470,000 is the difference. Couple of months. We also have special damages, which can be significant, plus costs. Costs usually run around 25,000. Special damages easy in the $50,000 range. So this adds up sort of quite smartly. Now, one of the things that's important is people say, oh, geez, I don't want to go to court. I don't know anything about court. I'm nervous about lawyers. I'm nervous going to court, et cetera, et cetera, et cetera. Now, most people have never been to court. They might have been to traffic court. They might have been there to pay a parking fine, but most people don't have any experience whatsoever. So their fear is one which is generated by discussions, by Facebook, by talking to other people, perhaps by reading the newspaper or watching movies. But it usually is not a personal experience. In this particular case, for the sellers, we're looking at, they had to decide to go to court. They had to decide which would have called for them to retain a lawyer, a litigation lawyer, to deal with this on their behalf. They'd have to file an affidavit of documents. And that's really a copy of the file that you've got. So your own file, if you printed everything up, that's probably the full affidavit of documents. There's not a whole lot more that would go in there. Maybe some email correspondence, some text messages, maybe something along those lines. But basically, it's the agreement of purchase and sale, the listing, the subsequent listings, the drop in price. And so it's not a telephone book. you know, you're probably looking at 75 to 125 pages of material. And that's the same material that you'd have in your own file related if you were acting for either the seller or the buyer in this particular situation. No witnesses testify. That's important. There is an opportunity for parties to be cross-examined on their affidavit of documents. That usually takes about 2 hours, and that cross-examination turns into a transcript, which is ordered, and it's available for the court. Time in just 2 hours. Now, you're going to get a fee for the entire day in court, because it could very well be that your case isn't reached till 3 o'clock in the afternoon, and it runs from 3 o'clock till 5 o'clock, and that's it. Okay, you're still paying for the full day in court. You're also paying for the full day in court if you happen to be first on the docket, and you're, you know, it's 10 and you're finished by noon. In any event, the requirement is 2 hours, and it's not necessary for the sellers to have attended and testified in court. And so what they got for that investment was roughly over $500,000. Now, don't walk away from that. Don't, if there's a computation and you inadvertently say, well, let's get on with this, we haven't sold, let's move on to another purchaser, let's give these people a mutual release and move on with it. I have a case now where it's precisely that situation, where the listing agent thought that they couldn't relist on MLS unless there was a mutual release, which is completely incorrect. And they're being sued for probably, well, about half of this sum of money, because their lawyer on their subsequent sale told them, why did you sign that? That was just crazy. In any event, that's in a sense the case. Now, one of the things is the buyers provided no expert witness to assist the court in respect to the listing of the property. So whether or not that would have, it was only sitting at the full price for 2 weeks. So that seems quite reasonable. The court viewed that. I'm not sure that any expert witness evidence would have been all that helpful because it was pretty quick. Mitigation. The date of assessment is determined by what is fair in the circumstances. Where the vendor retains the property to speculate on the market, damages will be assessed of the date of closing. In other words, the vendor doesn't have to sell the property, even though they sold it once. They can say, you know what, I was going to sell, but now I'm not going to bother. They're still entitled to money, and the court will determine that. So that's that step. There's now one thing that the judge did point out is that there's actually no positive duty or obligation to mitigate, apart from the fact that it's reasonable to do so under the circumstances, and that it relates to the calculation of damages. So when we sit down and do the math, you better have mitigated or taken some steps to minimize that amount if you can. And look at the interesting thing is, when we look back to 10 days of negotiation and we bumped up the value by $70,000, that credit was passed on to the buyer. So that's very helpful from that perspective. And of course that it's really just the law related to mitigation is really one of working the mathematics, as opposed to you have to mitigate, which would be the court coming along and telling the vendor first go round, you already had one bad deal, you've got to get yourself involved in a second deal no matter what. No, they don't have to do that. So, but if you're suing somebody, you got to work out the math, and you have to demonstrate that you did your best to make it as limited as possible. Now, here are the average prices. Now, I haven't bumped it up to, places in the $2 million range, but these were the prices that were the average price for a single family home, which includes condo, apartments, et cetera, and detached, of course, as we start out in 2017. So the first one, which I've put in, and I put this in all the time because there's actually 12 numbers that relate to the year, and they start really with the end of January. But I'm looking to go back to the beginning of January, in which case we actually need 13 numbers because we have a $38,000 increase just in the month of January. The big bump up took place in February, where it goes from 768 to 876 in 1 month. Then it slows down in terms of its acceleration in the month of March, all right, going to 915. It's still accelerating, but our foot is not on the pedal to the same extent that it was in February. That's important to be aware of in terms of assessing the momentum of the market. And the interesting thing is that by the time we got to April, it was the April numbers were only up by another roughly $3,000. So it just tops it off. It's pretty well coasting. Now, the interesting thing in terms of this particular deal is we didn't see the 915 number until a day or two after this deal was struck. So it struck on, I think, just recalling, I thought it was the 2nd of April. It probably would have been the 4th of April when we would have had the March numbers released. So it's very important to see the March numbers, but that information wasn't available in this particular transaction. Then we have the market acting as it usually acts. We had a peak in April. It started to decline. It went down in May, went down in June, down in July, down in August, and sort of like, oh my God. And when did they do their deal? In August. Geez, couldn't be worse, but that's what happened. Then the market reversed itself in September, went up in October as well, and then coasted slightly downward in November and December. But if you're a buyer, you might actually want the transaction to be completed as soon as possible. We're looking at 862 in May. Why wait that time? 918 in April. Like, why not try and get this thing sold as soon as possible? Don't hold on to that number to trigger it for a full month. In this particular situation, the buyer waited here for a full month before they communicated their intention to, in terms of anticipatory breach. So here, it would actually have been better had, rather than the second one, transacted in August, it would have been better September or October, just to get by those summer months. However, you can never be too sure in terms of the market. But these are the things that you would might have been called into play. It wasn't. Now, example of other damages. So we've got a couple of things. Real estate agent's commission on the sale, that gets paid. Legal expenses on the sale, mortgage prepayment expenses, moving expenses, loss of deposit on a purchase. That's a possibility, and nothing was indicated here in this particular transaction. Possible commission on a purchase, legal fees on a purchase, mortgage arranging fees on a purchase, carrying charges, liability, carrying charges on both properties, moving expenses with a second move if somebody has to put their possessions in storage, and then other expenses related to the failure. One of the things that I would comment here, and just something to be aware of, is the stacked deal. If you're coming along and buying a property and you're buying it from a little old lady who is going to a retirement home, there's not going to be a stacked deal. So we're sitting in a situation where her deal falls through, and it's just the deal falls through. That's it. That's what you're responsible for. And you're not responsible for all this other stuff related to her purchase. Now we move across the street, and there's a young couple who are, moving upwards in the market to, the $3.5 million range. All of a sudden, we have all these secondary expenses related to their purchase. That's very unfortunate, and I'm not sure that it necessarily done. So you'd be wise and careful to eliminate any obligation to pay these fees from 8 through 14. Currently, that's not the case in terms of AREA. It is the case in terms of some other jurisdictions in the States where it's only the deal that you're talking about and what's fair under the circumstances. In any event, it's just a negotiating position. Now, from the seller's perspective, what do you want to do with a situation that's gone sour? You want to monitor the market after it's sold. You want to watch for the buyer's finances. Does this guy have enough money to close? And be very worried if that's the case. You want to accept any repudiation of the agreement and act as quickly as you can in respect to the resale. This would have saved them $100,000 easy if they had dealt with it quickly. They didn't. They sat on it for a month before they figured out what was going to happen. And that damage flowed through, of course, to the purchasers. So what you don't want to do is you don't want to cancel the contract. You don't want to have it go null and void, and you don't want to sign a mutual release. Those are the things that you don't want to do. What you do want to do is have the contract come to an end. You want to allow a breach to take place. You want to look for and accept an anticipatory breach, which means that now you're getting to sell the property in April or May rather than waiting until August and then trying to sell it then. And you want to agree to any direction relating to the deposit, moving the deposit into a better investment. So let's say if it was not in an interest-bearing account, you realize we need to put this in an interest-bearing account, which is going to generate some money because it's going to be tied up for a while. From the buyer's perspective, it's really just a flip. You want to monitor the market. You want to be mindful of your own finances, approvals, and mortgage financing. This is something which, how did the buyer in this particular case, the day after closing, realize he didn't have the money? Couldn't have been a conversation that took place with his own agent. Or they would have put in a condition, whatever. In any event, just not good. Don't get caught. If you have a client coming forward and saying, I've got the money, I can close this deal. So, raise the issue. Well, what if you did, do you have something in writing from the bank? No, but I'm on good terms with my bank manager, et cetera, et cetera. You want to clarify that they have the money and that they have a secondary source of funds that would be available anyways. Oh, well, I could put a mortgage on my investment property. I've got the room to do that. Okay. Or I could borrow money from my business or whatever. In this particular case, of course, that was just not a possibility. You want to initiate repudiation of the agreement as soon as possible. Say, listen, I need to get out of this deal, and convey very clearly anticipatory breach of contract. Had they done that a month earlier, they probably would have picked up $100,000 in this situation, maybe more, who knows. What you do want to do is cancel the agreement. Yeah, I can't close. Why don't you get the second person to take over? You do want to have it go null and void if that can take place, but you'd have to have, let's say, some conditions in there for one reason or another. And you're more than happy, of course, to sign any kind of a mutual release. So from the perspective of the buyer, do up the mutual release, have it executed, and forward it, send it over, and let the sellers go ahead. And if they sign it, they sign it. Could be a big mistake on their part. That's what, but both parties, of course, in this situation are have opposite interests. So you don't want to have the contract come to an end. You don't want to wait for the breach to take place. That is August 30th, and then say, I don't have the money. You're in a much worse position. You don't want to wait to offer an anticipatory breach. You want to do that as soon as possible. And again, you'd want to have the deposit yielding a decent rate. So that's kind of it. I'm not sure whether there are any particular questions here. So
I do have questions.
Okay.
Hey, Brian, it's Jack.
Yes, Jack.
So actually several. Let's see. Realtor's liability for not advising both buyer and the seller to contact a lawyer in a timely fashion for legal advice. I'm assuming that realtors in this scenario may have been imposing as lawyers for about 10 days there.
Yeah, exactly. And it's a mess. And it's sort of like, don't do this. Move it on. If you can't handle the transaction and you look and it looks like it's about to explode, I say call somebody immediately and have legal advice that's available on both sides here. That would have been helpful. The market was going to explode anyways, but at least that would have been helpful and would have protected, I think, the real estate agent from any potential liability if they can be shown to have acted properly. But a mistake can be, and look at the erosion in terms of the numbers in just a month. I mean, if it's going down, this is something like $15,000 a day.
This was
So yeah, don't call somebody. What's it costing? Well, $15,000 a day.
So after the decision, right, for damages that buyers have to pay, any knowledge were the buyers later on pursuing any litigation against realtor or realtors and their insurance?
I'm not sure. Now, most of these types of cases are settled. I'm not aware of anything in this particular situation, but there wasn't. Now, and let me say for anybody who looks up the case, and you would see the names of the real estate agents who were involved. There was no indication in the judgment that the real estate agents had done anything wrong. So that would be, you'd have to hear a separate story from the buyers saying, oh, we told our agent all these things. Well, hey, listen, maybe it was well documented, maybe it wasn't. So this is a situation in which certainly Form 127 should have been used, and wouldn't have hurt to have sent out an email to the effect that you've authorized us to proceed. And how many times are offers put in without any conditions in a bidding war? You know what? We passed on it, and there's ways of handling that to a degree. So financing, you've got to find the money in ahead of time. Don't start looking for it afterwards, which was the case here. Second thing, if it's an inspection issue, it's not a good thing but and it's costly, but have an inspection conducted prior to the offer going in. It's, might cost $500, but it's $500 well invested if there's a significant problem that leads you to not proceed to put in an offer. By the way, my son-in-law has 4 inspections on houses that he doesn't own, but we wanted to be cautious, so we
Right.
did.
Makes sense. And a question about, in this specific case, realtor commission. It didn't close. Were realtors following up on commissions from the buyers for breach, or it was simply buyer's realtor wasn't compensated, and then I guess seller's realtor was compensated when it was sold the second time? Do you know how that
No, I don't have any information, and that wasn't in the judgment. So the only thing that my only source of information in this case is the judgment by the judge, which is then made public. So whether or not in this particular case commission was paid, you're entitled to be paid for putting the deal together, not for the closing. So the risk is out there. Secondly, some people will take the position, well, if we're the listing agent, we're going to get paid a second time around anyways. So, we'll just suck it up and not charge a commission first go round. That's very nice, but there can be many reasons why a buyer's agent might want their commission that they view as, listen, I've been working with this person for 2 or 3 years. This deal has gone sour. They'll never retain me again. I want to get my share, and they're entitled to do that under the MLS rules. So, first go round, they ask for the money. Second go round, they say if the listing agent is not going to cooperate, I will take an assignment of your listing agreement and sue your client, the seller, directly for my commission. And they can do that. What happens is off the top, they get all of their costs. And then the commission is paid first to the cooperating brokerage, buyer's brokerage, and then the balance is split 50-50. So a listing agent has to be very cautious in terms of having someone go along and agree to do that.
Not to cross promote across these videos, but I would tell you, Jack, that we've done a whole session on collecting commissions when deals go bad, where we've addressed these very facts as well, in case you're interested.
Can you repeat that for a moment? You kind of cut off for a moment there. So
sure. I said not to cross promote to other videos, but we've done a whole session on collecting commissions when these types of deals go bad, and you can view it on our portal, and we deal with these sections particularly and how they work.
Great. Okay. And is there any more input, Brian, on let's say in this case, because you went so deep in details here, how may have special damages broken out, or
no, that's usually something that they would file or they would either agree upon. So right at the outset, they might have agreed that the special damages were $68,412, and they'd be broken out. Only the parties would be aware of that. They could go back to court if that was in dispute, but usually we're now talking nickels and dimes. So they won't. We usually agree on what the compensation has to be.
And from your experience, when sellers are faced with this kind of a situation and they have to decide to go ahead with, well, there's a decision whether they want to go with litigation or not, and so on. Kind of from your history, what would be percentage that they can recuperate of their legal fees?
Well, they usually get about half.
Okay, perfect.
So if they incurred legal fees of $50,000, for example, they get half of that back from the other side.
Perfect. Thank you. This was wonderful.
One thing that I would mention, which I intended to add it and I didn't, and that I really put these slides together 2 years ago and didn't know today's numbers. But if we fast forward from to February of this year, the numbers that we were looking at in terms of 2017, when we bumped up to, I think, 918, we're at 910. So what really would have happened is, had the buyers been able to get their financing together, even pay excessive well to allow them to do this, they would have pretty well broken even as of February of this year. Then we had the pandemic, which is a separate issue. But what I'm saying is 2 years was all they had to hang on. So they could have closed the deal and not known about the numbers, not known that the house down the street sold for $200,000 less. Just ignore that particular fact. And their house would have been worth what they $500,000, more than $500,000 out, and they have nothing to show for it. Absolutely zero. So that's important, I think, to be aware of. And many people make a quick decision on principle, and they don't do the math. Here, the math would have said, yeah, you overpaid by, maybe $500,000, but who cares? Who cares? As of February, you pretty well would have been, February of this year, they would have been fine.
Right. Yeah. I mean, there's nothing illegal about breaching a contract, but it's still kind of in reality, practically speaking, it's really not an option.
Yes. I'm assuming that the funds were not okay. Any other questions anyone has?
I think that brings it to a close, Brian. We're at 11 o'clock. Thank you for the punctuality and thank you for your time. I will be posting this on our group and some other forums, but thank you so very much, Brian, for everything. And on behalf of all of us, well attended, and thank you everyone for coming.
Okay, thank you very much.